Hello, my true crime lovelies. How are you? I hope you are well. I hope you are as lovely in life as you are in my mind. And if not, I hope you're on your way to getting there. I know I've got a lot of viewers who suffer from chronic pain, and so I know every day is not a good day. I try to acknowledge you guys. It's okay to not be okay. It's okay to be on your way to being okay. Sometimes we have to go through the valley to enjoy the mountains, right? Anyway, that's not why you're here. We're going to talk about Donna. Donna. I think Donna's writing her own motions. She's giving a new meaning to me. You know that expression, going through the motions? I think that's what's happening on Team Adelson. I've watched tons of videos. Shout out to Kathy over at Gossip Rumor and oh my goodness. Deep breath. Pregnancy belly taking all my oxygen. Kathy, head gossip over at Gossip, Rumor, and Innuendo. She was the first one who broke this that I saw, and then I've watched a bunch of others. I'm going to put my 2 cents on it. So we're going to take a look at it. First, we're going to thank the members. We're at over 700. I appreciate all of you. Here's your sound warning for those of my lovelies with sensitive ears. You've got 33 seconds of music, and I'll see you on the other side. Let's just get right into it. I will say this is one of the more emotional motions for new trials that I've seen. We know it's customary, right? It's pro forma. It's not the first one we've seen after a defendant, shout out to Sue Hopper, has been found guilty. So it's not a surprise, but this one is emotional. It seems a little petty to me. And so I went to Petty University. So we're gonna get real petty with them too. Who is that? I can't think of her name. She has the teal hair though. I don't want to steal her Petty University saying. It'll come to me while we're doing this. But anyway, shout out to her too. Okay, so Donna Adelson, she was convicted on September 4th. They're looking to interview juror number 5 and juror number 7. You and I talked about juror number 7 when we were with Kathy from Gossip, Rumor, and Innuendo, and Judy from AA Legal Focus. She was a jury 4 person. Young, I think she's 26. I thought she was like early 30s. I'm old enough to be her mother. I have a daughter older than her. Super smart, super with it. And then juror number 5, which I think Joe calls him the plumber or something, the sprinkler man. There was another juror, Evan, who also spoke, but I can't. He must have been 6 because I think we did them in succession. Right? Not we, but they were on the interwebs in succession. Anyway, so she files her motion for a new trial on the following grounds: juror misconduct. Wham. They're talking about me on the internet. Verdict is contrary to the law or weight of the evidence. I don't know how that can be, right? If you have the option as the defense to lay out what were the verdict options. It's not like the jury was like eeny meeny miny mo, right? And they removed the lesser included. So what? The court erred in a decision of any matter of law which arose during the trial. Wah, wah. There were a lot of motions filed where they were trying to get things excluded, but if it wasn't raised otherwise, like contemporaneously during the trial, they don't really have a leg to stand on. And then 4, the other cause not due to Mrs. Adelson's fault. She did not receive. Oh, 4. For other cause. So something that has nothing to do with her, she didn't receive a fair and impartial trial, right? So she wants to interview jurors. Footnote, although the jurors have identified themselves through social media or media appearance, the court previously ordered the parties to refer to the jurors by their juror number. So like if they're calling the jury members to task. They're reminding the judge, you told us not to, so that's why we're doing this. We're following your rules. So they were told you are also not permitted to communicate about this case with anyone, including your spouse, family members, friends, neighbors, and even your fellow jurors. No communication includes no in-person, telephonic, or electronic comms, such as emailing, text messaging, and then in bold and italices for emphasis, posting information on social media or a website or any other form of communication. So subsequent to the trial, juror number 7 went viral on TikTok concerning her jury service. She revealed that she posted to TikTok during the trial. So this gets a little bit tricky because as I understand it, what she said was, now the post has been deleted, so we can't go back and dissect it, is that she was selected for a jury. She posted that on August 26th, which was the third day of testimony, but that she did not include which trial she was on a jury for. So I think one might be hard pressed to say that it was readily identifiable that it was Donna's trial, right? I remember it's the third day of trial because I went to Sarah Boone's family trial. Please hold. New York streets. I'm not going to out-talk the sirens. Please hold. Okay. Oh, Manhattan, I love you. I'm 10 stories up. You would think I wouldn't hear it clearly, but it's loud. Okay, so went to the Sarah Boone family trial on August 25th, right? So that was a Monday. So the 26th was a Tuesday. Testimony had started in Donna's trial that Friday, whatever that ends up being. So I may be remembering it incorrectly, but I feel like it was opening statements and testimony on Friday. So posting it on Tuesday doesn't necessarily, like, to me, be like, oh, I wonder if that's the Donna Adelson trial that she's on, right? And she talks about, the juror, I think it's JC, Lacey with the J, and she talks about being in, like, mommy groups. Her son has had multiple surgeries. I don't want to put all her business out there. It's on STS if you want to go watch over there. But basically she's in mommy groups and she's in groups that help support her and lift her up while she goes through these struggles with her son, right? And so she basically was like, and this is a note, this is how I understand it from watching her on STS. It was more like a relief of, like, God gave her something to keep her mind occupied other than being so singularly, like, myopically focused on her son. So she was saying it more as a relief of, like, oh, thank goodness I got this, I have something to focus on. And it sounds like she focused indeed when you hear her talk about her notes and organizing and the way, you know, she kind of rallied the troops. So I am not sure. I feel like Donna and them
By the way, how's your mama at now?
Donna and them are grasping at straws. The undersigned identified, she posted on TikTok that she was selected as a juror on August 26th. So a flash drive with this video will be provided to the court. As the undersigned has been informed, that particular TikTok was deleted by the juror from her account. So hopefully, I'm not sure why she deleted it. I mean, maybe there are posts where people are like, lock her up, I hope it's Donna Adelson or whatever it is. I'm not sure. But is that in and of itself enough to have, like, jury misconduct? Are you saying it's misconduct because it defies the orders? Did it in any way impact her ability to listen and be impartial is really at the root of the matter. I get that we want them to follow it to the letter, and maybe, you know, judges specify going forward, do not post anything that you were selected, even if you don't say the trial, like, don't mention a single word. Okay, so they want to interview her concerning her social media activity during the trial. I don't know what she's going to say that they can't see on the internet unless they're saying a bunch of them were being deleted, but they're not making that accusation. So additionally, juror number 5 appeared on the podcast Surviving the Survivor. Shout out to Joel. During his appearance, he revealed he considered how Mrs. Adelson reacted to the evidence and testimony admitted during the trial. although he subsequently stated he obviously, in quotes, did not consider that during deliberations. That he considered Mrs. Adelson's reactions whatsoever is concerning, as her reactions are not evidence and are extrinsic or external, so happening out here, rather than which inheres in the verdict. So it should have no bearing on the verdict.
But listen, Mrs. Adelson, you should have fixed your face during the trial, ma'am. Judge Everett told you multiple times to get it all the way together, girl. So if you didn't want people even possibly, mighta, coulda, woulda, shoulda, considered your expressions, you should have sat stone-faced, right? Like, you were over there shaking your head, oh no, and mouthing, and oh my God, a verdict. Ma'am, you were putting on a show. Don't be mad because people showed up with popcorn.
As a result, the undersigned seeks to interview juror number 7. Okay. Concerning his consideration of Mrs. Adelson's reactions to the evidence. Based on the fact that he said he didn't consider it, I don't know what other questions. Are you trying to have a gotcha moment? So they want to have these interviews. They go into this potentially harmful misconduct is presumptively prejudicial. I don't know how saying I'm a juror or I've been selected on a random jury is prejudicial, or saying I noticed her expression but I did not follow it. Her body language, I mean, we at home were looking at her body language, right? Her body language, her outfit. Yes, I know they said we're not supposed to.
I wasn't on the jury, so I could do what I wanted to do.
Maybe that's one of the disadvantages of jurors doing interviews so soon after, because you have X amount of days to file this motion, right? I think it's 10 days or whatever. Maybe do it after. I know everybody is thirsty to hear their thoughts, but then I think it gets overanalyzed what they said. Just me? Let me know what you think. So, does not have to conclusively establish that the alleged juror misconduct occurred and actually prejudice this case. So you can make false allegations. That's how you, the alleged jury, you don't have to conclusively establish. So I guess by a preponderance of the evidence, are we doing like civil case threshold? It is only necessary that the party establish a basis for an inquiry or grounds the party believes may exist. So that is, you can grasp at straws if you have a whiff of not even probable cause of misconduct. So once improper conduct or contact or juror misconduct is established by juror interview, the moving party is entitled to a new trial unless the opposing party can demonstrate that there's no reasonable possibility that the juror misconduct affected the verdict. So in Georgia, I trust, as always, and Sarah Kappelman, I'm sure they will be able to demonstrate there's not a reasonable possibility that it affected the verdict. So we'll wait on their response. If juror misconduct is confirmed from the juror interviews, the undersigned will request leave to make more extensive arguments concerning why the juror misconduct in this case warrants a new trial. So I'm not a lawyer, as you all know. I'm here dishing out my 2 cents. It would seem prosecution would also get to interview the jurors, and so they would be able to say it's not confirmed. They would be able to have argument, right, about, well, we interviewed them and this is what we took away, and then the judge decides if we move forward. Me, myself, I don't see it. Now, y'all know I was all on board for some jury interviews with Lori Valadabel and Mr. Blue Shirt, who was like, I was driving home last night before the verdict was determined, and I thought, she's doing 3 lifetimes. And it's like, sir, how do you know that? But listen, for this one, I'm not seeing it. So verdict is contrary to the law or the weight of the evidence. I just disagree with this. In Robinson, the court stated succinctly, rules of criminal procedure and the court continue to recognize the critical need for some form of discretionary judicial review to serve as a safety valve, talking about Judge Everett, in those cases where the evidence is technically sufficient to prove the criminal charge, but the weight of the evidence does not appear to support the jury verdict. So I don't know. It's pretty weighty when you buy a one-way ticket to Vietnam after making multiple phone calls about an emergency visa and how a 30-day visa will never do. When you say things like, you know, I'm next, but I won't let that happen. Their main argument here is that she wasn't involved in the initial plot to murder Professor Dan Markel, that she later became involved, and so that Therefore, she cannot be guilty of first-degree murder. So I trust that Georgia and Sarah Kappelman will be able to go back and pull out the pieces that show that she was involved prior. Like, even if we're saying, well, she didn't know until the night Katie came by and she dropped off the money before, that doesn't really make sense, because then there would have been a phone call where Charlie told her, like, hey, Katie is here and she's responsible for or her friends are responsible for the murder of Danny, and you need to get over here with some money, right? I know there's a call where they're saying he was told about it, and like, or a text, and we're on our way to Tallahassee. But what about like prior to that, like having the license, his license plate number, changing the children's name to Adelson? Like, there's definitely motive there, and I know, well, they don't have to prove intent, right? I don't know. It's, or do you have to prove intent in first degree? I think it's second degree. You don't have to. There seem like plenty of intent. A motion for new trial requires a trial court to evaluate whether a jury's verdict is contrary to the weight of the evidence and to act in effect as an additional juror. So that would be Judge Everett. He's seen the evidence in both cases. I just don't see him being swayed by this. The standard is different than the one used by a court in ruling on a motion for a judgment of acquittal, which utilizes a sufficiency of the evidence standard. And I think at the close of the state's case in chief, they asked for a judgment of a motion, or they filed a motion for judgment of acquittal. Okay. Florida courts have held multiple times that when considering a motion for new trial under Rule 3.6A2, based on a claim that the verdict is against the weight of the evidence, the trial court must exercise its discretion to determine whether a greater amount of credible evidence supports one side of an issue or the other. I mean, I didn't see any evidence that was incredible. We're going to talk about the jailhouse informant snitches or whatever, but the jury gets to decide their credibility. And like I said, I noticed they didn't put in number 6, Evan, juror number 6, in here, but he talked about specifically, the others may have, but I remember his description specifically talking about based on who they are and what they had to gain by their testimony, he weighted what they had to say. Again, they're repeating, trial court acts as a safety valve by granting a new trial where the evidence is technically sufficient to prove the criminal charge, but the weight of the evidence does not appear to support the jury verdict. I'm calling that a defense mea culpa, because they should have put in the lesser includeds then. At this stage, the court must make a finding.
That's you, Judge Everett. They're telling you must.
That Patricia Byrd was credible before considering Mrs. Adelson's alleged confession to Byrd. That is what the jury does. The jury decides credibility, right? They can give them they find them not credible at all, somewhat credible, very credible. It's not, you don't stop someone from testifying because the opposing party doesn't feel they're credible. But listen, maybe that's why they didn't put Donna on there.
They're like, we're not sure you're coming across credible.
But that's within your party. So under no set of circumstances can Byrd be considered credible. Did they file for something for this ahead of time? She testified the defense investigator with whom she spoke was a white woman. Mrs. Kahn was obviously not white.
Maybe she's colorblind.
I mean, the jury heard all this. I'm being silly, but seriously, the jury heard all this. They get to decide. We don't know how much weight, if any, that the jury put into what Miss Byrd said. She further testified that she told both Mr. Varnez and Miss Kahn that Mrs. Adelson confessed and that Mrs. Adelson offered her financial incentives like teeth, a trailer, some land in exchange for perjured testimony. And then these other two, both Mr. Varnes and Miss Kahn, disputed those claims. I believe it's Mr. Varnes who was the private investigator for Donna prior to her current counsel. Like, he was under Rashi, and now we know why they fought so hard to have Mr. Varnes not disqualified as part of that tainted pool. and have him come back and say, because apparently Miss Bird has been on the book since last year, summer, when Rashi was still in full effect. Additionally, Ms. Khan testified she never met with Mrs. Adelson. Thus, unless the court were to believe defense counsel conveyed to Ms. Khan that Miss Bird was to be offered money for false testimony, Miss Bird's testimony should be disregarded completely. Did you argue that in your closing, like at the time of the trial? Because the jury heard all the evidence. Are we questioning now the jury's ability to discern the credibility? Because then why do we have jurors? Why not just have all bench trials? So the same is true of Drina Bernhardt, except Drina came in December of last year, so Rashi was long gone. Miss Bernhardt's motivation to lie was and is significant. Okay. However, the surveillance video admitted into evidence establishes that she and Mrs. Adelson worked together to write the script. Jury members who spoke out also spoke out about this. They watched that entire video. I guess it was hours long, where Miss Donna seemed real comfortable. She was walking around real fine. Not the little sad grandma appearance that she showed up to in the courtroom. So they could see in its entirety that what the defense was trying to lay out. They purported that Drina was like,
write this, write this, write this.
and that's not what the video showed. So, okay. The theory of the state's case was that the defendant is guilty as a principal to the charge of murder, which is how you get to first degree, right? Because she agreed to the plan that was carried out by her son, Catherine McBenoit, Sigfredo Garcia, and Luis Rivera, and that she paid for the crime to be carried out. There is no evidence that Mrs. Adelson committed any act or uttered any words in furtherance of the offense prior to it being completed, and for that reason, the evidence is not sufficient to support her conviction as a principal to first-degree murder. So because she was clever and walled herself off with the train cars that the state presented, she gets to walk away scot-free. Somebody came up with the idea. Are we now throwing Charlie under the bus? Because we know his appeal is pending. Like, he's responding to the appellate court's response. Additionally, there is no evidence other than the adoptive admission. Adoptive. I love that the state adopted it for Donna, or put on the record that she adopted it. They weren't ready. Donna's team was not ready for that. Georgia laid it out like throughout the entire trial. She left little breadcrumbs, and then she showed them that baked cake at the end. Ta-da! Oh, from Charlie Adelson's trial testimony, that Mrs. Adelson was aware of her son's plans until September 17th. So they're saying he was shot on the 18th. Okay, so they're backing it up to the day before because the money was dropped off on the 18th, right? The night of, and Katie spent the night. Dan was still alive. By the time she left, he was deceased. So I didn't get that even in the adoptive part of the story. Like, at what point on the 17th was she aware? And if she was aware, what did she do to stop it the morning of the 18th? Because she was all in. She's calling Wendy about the TV. Javi's calling Wendy about the TV. I think one of the TV people, someone from Best Buy, called Javi, and he was like, oh, no, you need to call Wendy. So you guys let me know. I don't remember. And I'm still watching some of the trial and rewatching, because sometimes like I just go off on a tangent in my mind and I don't focus. But if you remember what was entered into evidence that she became aware on the 17th, let me know. No evidence other than adoptive admission that Mrs. Adelson was aware of her son's plan until the 17th. That was a Thursday. Okay. I mean, I guess if they're able to prove that, what would they say then? It was an accessory? But then it still doesn't make sense. Why did they remove the lesser included, right? If they feel like they made that case and they showed sufficient evidence to show she wasn't a principal, why did they take the lesser included off the table? Like, that's just bad counsel. Okay. Although a person can be convicted as a principal to a criminal offense based on words alone, Williams v. State, there must be competent substantial evidence that these words were spoken in advance of the crime. Because there were no wiretaps, we're saying it's not. I don't know. I think they'd have to go back. Yeah. So Williams v. State, I believe, is like the Denise Williams, and I can't think of her second husband's name, but it was the husband's best friend. The best friend was insurance seller, or whatever you call them. And he killed Denise's husband, and they pretended like he was eaten by gators. Like he had his waders, they left them in there. Like he didn't have his waders on, he did have his waders on. We would have found the waders, so then they went and planted the waders. The mom of the husband, of the murdered husband, oh my, I felt so bad for her. She has these little two blonde pigtails. Once her son died, Denise prohibited the mom from seeing their child, like her granddaughter, because the mom was like, something is fishy here. And right before he died, they did something with increased the insurance. They only got busted because the second husband, the insurance seller / best friend, was stalking Denise. And so she went, and I guess he had pulled a gun on her. She went to the police for protection, and the police were like,
Oh, little miss, we've been trying to get you on this murder charge for several years now. Do tell us what's going on.
So they arrested her husband, which I think they were going through a divorce. The second one arrested him. He was like, listen,
I did the crime, but I'm not going to do this time alone.
and so she was convicted, and I think on appeal, the first degree part was overturned because there was no evidence to show that she knew ahead of time. But that's only 2 people. Like here we have like a full-blown conspiracy with the Adelson family, right? And the Brown people. I don't know. I feel like they're reaching. But because she did get part of her sentence overturned, I think that's why they're making that connection. But I've been thinking about it, and I can't think of like concrete evidence that was shown that she knew prior. Well, we have the June attempt, right? Not June Umchenda, but June 2014, where Louise said that they drove up, and then he didn't want to do it because the kids were involved. And rumor is they paid someone in advance, and those people just took the money and ran. Because what are you going to do? Call the police and say your hitman ran off with your down payment? I don't know. I just feel like it's a stretch. As acknowledged previously, intent is an operation of the mind and may be established by circumstantial evidence. There certainly is no direct evidence Mrs. Adelson intended for Mr. Markel to be killed. Okay. However, there also is no circumstantial evidence that Mrs. Adelson wanted Mr. Markel to be killed. Okay. Even if there's no evidence to establish the second element, that she did some act to assist the other person in actually committing the crime. So I'm thinking they mean ahead of time, right? Because if the act of her having the money being wet, Charlie saying she washed it, that is circumstantial evidence. But it happened after the murder. McBanawa testified that per Charlie Adelson, her parents had stopped by his residence. We also have the text messages outside your home or at your house or whatever it was. However, McBanawa did not testify that Mrs. Adelson or her husband dropped off any money that night, but she did say that Charlie was like, my parents just left. And the state's expert agreed the state could not place Mrs. Adelson or Dr. Harvey Adelson's handsets at Charlie Adelson's residence on July 18th, 2014. Even if Mrs. Adelson and Mr. Harvey did stop at his residence, it would have been approximately 9 hours after Mr. Markel was shot. The 9 hours is a red herring. Who cares about it? Like, she's not going to pay anybody in advance given what happened last time, right? And it's a red herring because at the time, they didn't know Donna stopped by there. They didn't get that information until Katie did her proffer in 2023, right? After her second trial where she was convicted. So by that point, if we're in 2023, we don't have the cell records for 2014. It's too many years later. So that's why the expert is saying the handsets can't place you there. But the text message puts her there. Yes, it's circumstantial, but it puts her there. In fact, at the state's request, the court found that Mrs. Adelson had adopted Charlie Adelson's prior testimony. Yeah, you guys weren't objecting. You weren't paying attention while Georgia laid those breadcrumbs throughout the trial. And you didn't come up with the defense. You were just punching holes with your rusty hole puncher. This included Charlie's testimony that he paid McBanowa from his own money, which he kept stapled, as confirmed by McBanowa. Was it confirmed? Because Charlie also said, the money is damp because my mom washed it. Oh, they're talking about the stapling. So they said Ryan Fitzpatrick and June Umchinda. But we also know that the domestic coordinator was giving Charlie the money, so perhaps she stapled it. It would have been nice if they had someone in Donna's sphere that said they got stapled money from her. Frosting on the cake, though. We still got the cake. Charlie's testimony also included the fact that he did not tell Mrs. Adelson he paid Meg Banowa for the shooting until September 17th. Oh, they're saying September. Okay, the shooting happened July, so never mind what I said before. I'm mixing up the months. The shooting happened in July. He's saying, so July, August, 2 months later is when he told her, is what they're alleging. Charlie was trying to protect his mom. No evidence was presented that Mrs. Adelson was aware of anything other than Mr. Markell had been killed prior to September 17th. Okay. Except the I'm outside your house and Katie's testimony. That's circumstantial evidence. The defendant in Staten drove the perpetrators to the scene of the crime, waited across the street while they were committing the crime, and then drove them away in the car. In these circumstances, the jury could legitimately infer that petitioner was a participant in the crime. Yeah, but see, the way the Florida law is written is you don't have to show that Donna got her hands dirty, so to speak. Only that she was involved in the conspiracy, right? She didn't have to be on scene. Affirmative acts such as these are common in prosecutions under the principal statute. Common, but not required. Judge Brad Thomas explains the rules in Ammons v. Ammons as follows. To sustain his conviction as a principal, the state was required to establish that appellant intended that the crime be committed and do some acts to assist the other person in actually committing the crime. The money you helped, you gave you payment. The solicitation. Even if they only go down, like just to say on some random technicality, she still would get 60 years for the other one. The other two, the solicitation and the conspiracy. She would still get 60. Maybe that's why they didn't want to have her sentenced to the life at that point. They probably just didn't want it on her mental. I don't know, guys. Okay. Although there was evidence that the defendant intended to participate in the crime, there was no sufficient evidence that he did some act to assist in the commission of the crime. I think the money is the assist in this. I think that's the act. The most that the evidence shows is that she knew of the plan at some point. That is not sufficient under the rule in Staten and Ammons. She knew and did nothing. That's okay. For me, it's just hard to believe that Wendy didn't know and Donna didn't know. Like, Donna is controlling what Charlie does. I don't think Charlie just goes off on his own. Well, one, I don't think anybody touches Dan without Wendy's approval because you're removing the father of her children. So I feel like just based on their level of enmeshment, there's a conversation about that, right? You can't just... I mean, you shouldn't be doing it anyway. It's all weird. But it wasn't her birthday present. They weren't like, surprise, look what we did for you. Do you know? Okay. There's more about this with Williams. You guys can take a look. I want to get through this and I've got like limited time. Okay. They're saying nothing about delivering money after could support her conviction as a principal to the murder itself, but she would have had to have discussed the amount of money prior. Now, I know Katie was like flimsy on the money. Everybody was like not counting the money, which I guess if you have $2 and you know you're going to get 20, you're not quibbling about it, I guess. I don't know. But Charlie and his mom had to have some conversation about this money ahead of time, right? And it involved her dropping it off. Like, why she didn't give it a week before, but I think it had to be after confirmation of the activity, right, of the murder, because they got stiffed the time before. So the state may also argue that Mrs. Adelson necessarily provided Mr. Markel's tag number to her son, who gave it to McBanawa, who then gave it to Garcia Rivera. However, there is no evidence the tag number was ever given to Charlie, let alone McBanawa, Garcia, or Rivera. So here's the thing on this. Rivera is illiterate, right? So even if it was on the paper, the only people who would know would be Charlie and Garcia, right? Sigfredo has never spoken. His appeal, he's exhausted all of those. Maybe he talks and can say, yes, that was on the paper. And that ties it together. And maybe he doesn't even talk to reduce his sentence, but to help out K-Mags reduce hers. We don't know because Garcia hasn't spoken. And obviously Charlie was trying to insulate his mother, so he made it after. Even though they have that weird text message between Charlie and Donna where when Garcia and Rivera get arrested, like, oh, maybe he didn't pay a drug dealer, but they were allegedly being extorted at that point. Well, if you know who did it, why are you speculating about not paying a drug dealer? It's like you're now thinking of a new lie together, which implies guilt. Anyway, no evidence was admitted during trial to establish the purpose for which Mrs. Adelson had the tag number in her 2014 planner. Well, you know who could have explained that? Mrs. Adelson, if she had gotten on the stand. So you left it to the jurors to decide to infer why she might have had that and his schedule. Finally, with respect to the second principal instruction, there's no evidence Mrs. Adelson made any payment prior to the murder, or that she, rather than Charlie, promised any payment prior to the murder. At worst, even if Mrs. Adelson dropped cash off, so they're saying it might have happened, at Charlie's house after the murder and signed the payroll checks after the murder, would establish her culpability as an accessory after the fact, but are not competent evidence as a principal to first-degree murder. But in that, you have to believe, beyond a reasonable doubt, that Donna Adelson was just doing what her son told her without question. So conspiracy to commit, they go through the second one. As was clear throughout the trial, there was no direct evidence of Mrs. Adelson's involvement in the conspiracy. The state proved as to Charlie, McBanawa, Rivera, and Garcia. So that was really their defense thing, right? Like the Bart Simpson defense.
I didn't do it. Nobody saw me do it. There's no way they can prove anything.
Because of no direct evidence. But circumstantial evidence can be just as important. The evidence against Mrs. Adelson was the motive. Mrs. Adelson desired to have her daughter and grandsons move to South Florida.
No, there's circumstantial evidence.
There was certainly evidence Mrs. Adelson was not happy with the way Mr. Markel treated her daughter in the litigation process. There was no evidence Mrs. Adelson said or did anything to suggest Mr. Markel be killed a year after relocation was denied. I don't know, there's a lot of stuff happening in October of 2013. Okay, I've run out of time and we're only on page 10, so I'm gonna pause. It'll just be 60 seconds for you. Grab a drink, grab some popcorn. You've got 60 seconds. A little comfort break, courtesy of Judge Darrow. All right, it's a new day. For me, not for you. Okay, let's just hop back in. There's no evidence Mrs. Adelson was even aware, according to Jeff Lacasse, that Charlie Adelson looked into hiring a hitman in the summer of 2013. So that sentence is kind of convoluted. I believe what they're saying is in 2013, per Jeff Lacasse, Charlie looked into hiring a hitman, and there's no evidence that Mrs. Adelson was aware. Who cares? Did she have to be aware of that one? Maybe he did a bad job because they ran off with his money and he needed his mommy's help in 2014. You know, who knows? Okay, to establish a prima facie case of conspiracy, the state had to admit evidence that the intent of Donna Adelson was that the offense of first-degree murder would be committed. In order to carry out the intent, Donna Adelson agreed, conspired, combined, or confederated with Charles Adelson or Catherine McBanowa or other persons to cause first-degree murder to be committed either by them or one of them, or by some other person. I feel like there was circumstantial evidence that was admitted to that, like the car tag, the upset at the grandma motion, the money part. And again, I just don't think they took out Dan Markel without Wendy's prior knowledge, right? They're so enmeshed. The undersigned asked the court to consider the evidence without the state's spin placed on it.
I'm pretty sure the jury already did that. They already considered the evidence. They decided what was credible, not credible.
And they got to beyond a reasonable doubt. Certainly, Mrs. Adelson suggested crazy and offensive methods to her daughter to convince Mr. Markel to change his mind about relocation. Once the dissolution was final on July 31st, 2013, what evidence exists that Mrs. Adelson continued to have a motive for Mr. Markel to be out of the picture? If we ignore the emails where she suggested her daughter ensure Mr. Markel be obligated to share expenses with her for their son's college education, etc., all events which would necessarily take place after he was killed? Question mark. I feel like they're going back to, what was her name? Bailey. I can't remember her first name. But the one attorney for the defense, the expert in family law who was very unlikable and had questionable dental hygiene. Because she was saying, oh, they wrapped everything up in July 31st, 2013. But we know that dragged out into 2014 because he accused Wendy of fraud, right? Financial fraud. We also now know, which we didn't know in the last trial, that Donna had been in Tallahassee for weeks before Dan was served the divorce paperwork, moving money around. So maybe it would have also implicated Donna, or maybe Donna, with just her meddling hands, was offended that someone was going to question the money moving that she did. So I'm going to say that's evidence that there was continued activity, like the ongoing motions by Dan, the issue of the financial fraud, him withholding the $80,000. All of that was continued motive because it was pissing Donna off, because what was Donna's end game? To win.
Jibbers hasn't beaten the Adelson family yet.
Right? Where is the evidence Mrs. Adelson agreed, conspired, combined, or confederated with anyone else that Mr. Markel be killed? There is none. She wrote checks to Katie. I mean, we don't have any evidence that Charlie told her to write checks to Katie. You guys were doing that adopting of Charlie's story, but the jury doesn't know, and they get to decide if that's credible to them, right? At the end of the day, Donna wrote multiple checks out to Katie for working, and Katie was not working. So there's the evidence. The state's entire case is premised on speculation, impermissible stacking of inferences. Did you object to these in real time, and theory. Without the speculation, theory, and impermissible stacking of inferences, there was no evidence Mrs. Adelson ever agreed for Mr. Markel to be killed. So I don't know how the law is written. Does it say like you have to have documentation that she explicitly agreed? It feels like conspiracy implies that you don't, because you're conspiring. So there's multiple people doing different things so that not one person is a standout. Do we have to find a note that says,
"Dear Charlie, I'm so glad we're conspiring to kill Dan Markel,"
in order for us to move forward?
It's a reach.
The evidence of flight was not that she was fleeing. Oh, this is Donna, I swear. Are we still talking about this? It would have been a much better move to say, yep, I was scared shitless. I was trying to get out of there. I regret it. I didn't know what else to do. I was waffling between that and unaliving myself. And so instead of self-harm, I booked the flight, right? That would be more believable than,
"Oh, I just wanted to get away. My husband suggested it."
she's throwing everybody under the bus. Harvey, he suggested that they go to Vietnam. Charlie, he's the one who looped her into writing these checks and handing over money. Wendy, she had the most incentive to do it. And then even poor Rob. What did Jackie say in closing? He had an axe to grind.
About what, ma'am? About what?
He's going to get up there and accuse his own mama of conspiring because he has an axe to grind? Okay, I mean, he said some not so nice things about Wendy and Charlie too. What axe does he have to grind about a man doing life in prison plus 60 years? Like, it doesn't make any sense. They had to say something? Question mark.
Sometimes it's better to say nothing.
Okay, the trial court must exercise its discretion to determine whether a greater amount of credible evidence supports one side of an issue or the other. Okay, and when is the trial court meant to discern that? Although the fancy presentations prepared by the state may have been persuasive to the jury. You mean unlike that whiteboard that Miss Fulford had, or that poster board like she was at a science fair? Mrs. Adelson asked the court to look objectively at the evidence, removing the improper stacking of inferences on which the jury's verdict is premised. You guys let me know, do you remember them opposing any improper stacking of inferences? I mean, we won't fully know until we get the transcripts of the sidebar, but I feel like this is net new. You let me know, though, because I didn't see every minute of the trial, and I know some of you guys did. Count 3, solicitation to commit first-degree murder. State's theory on count 3 was that Mrs. Adelson convinced her son, Charlie, to find someone to murder Mr. Markel.
Yeah, she had a problem and Charlie liked to fix them.
The charge of criminal solicitation requires evidence that the person intends for the crime to be committed and that she commands, encourages, hires, or requests another person to engage in specific conduct which would constitute the commission of the crime. I think she did do that with Charlie. As the jury instructions set out, the state must prove beyond a reasonable doubt that A, Donna Adelson solicited Charles or Catherine or other persons to commit first degree. Now they're convoluting it. I mean, the state's theory was that the train cars, that Donna and Charlie were connected. So the whole Catherine thing is like a red herring, in my opinion. During the solicitation, Donna Adelson commanded, encouraged, hired, or requested Charlie Adelson or other persons to engage in specific conduct which would constitute the commission of first-degree murder. Well, did Charlie take it upon himself? Because clearly the jury did not buy Charlie's story of this extortion. So he is convicted of first-degree murder. Did he do it of his own volition?
Or did he do it because his mom was in his ear and put a battery in his back?
To solicit means to ask earnestly or to try to induce another person to engage in specific conduct. I could see Donna asking in earnest, demanding, crying, doing whatever it is she does with her face with no tears. The evidence admitted at trial failed to establish that Mrs. Adelson asked anyone earnestly or tried to induce anyone to murder Mr. Markel.
Potato, potato.
Rather, the competent substantial evidence establishes that when Charlie was speaking with Miss McBanawa concerning Mr. Markel, he would at times make or receive calls from Mrs. Adelson. So they're talking about only the non-circumstantial evidence, right? They're talking about direct evidence, which we know some cases are solely or mostly circumstantial. It doesn't mean the jury didn't get it right. Just like it's circumstantial if I go outside and the sidewalk is wet and people are carrying umbrellas that it had previously rained.
Like, you don't leave your common sense at the door.
Miss McBanawa did not testify to any messages Charlie conveyed to her, and Charlie, although transported from prison to testify, was not called as a witness. Did anyone ask her? Like, you had a chance to do cross-exam defense. Did you ask her about messages conveyed to her? As with the argument, because you had the opportunity, so you can't have the opportunity not do it and then claim, well, no one asked her, therefore there must not be any messages. As with the argument concerning count 1 above, evidence may have established her involvement after the fact and her complaining to Charlie about how Mr. Markel treated Wendy Adelson. There was simply no evidence she commanded, encouraged, hired, or requested Mr. Markel be murdered prior to the murder. Common sense and the plain language of 777 9311. If you know, you know. Florida statutes require the solicitation be committed prior to the crime. So again, this was Charlie's defense. Although in what he was saying is, we didn't ask them to do it. They did it based on Katie hearing that I was going to pay $350,000. So I didn't solicit it prior to it, but I paid for it afterward. It didn't work for Charlie. It didn't work for Donna. We need to move on. With there being no testimony from any witness or any evidence admitted that Mrs. Adelson asked anyone to murder Mr. Markel, the entire premise for her conviction on count 3 is simply
speculation.
And, as argued in court, an improper stacking of inferences. Okay, so they are saying they argued it in court. I hope they don't mean just in closing. I don't remember it. I'm still looking at footage though, but okay. For these reasons, Mrs. Adelson's conviction on count 3 should be set aside and a new trial granted. Fat chance. So the third one, court erred in a decision of any matter. They did file these contemporaneously. Court erred in denying Mrs. Adelson's request to admit into evidence the complete 2014 planner and 2023 planner. So we talked about this. They wanted the 2014 in there to show that she had previously been looking to sell items, right, in 2014, and some of those items that had not sold appeared in 2023, so therefore you couldn't say that wasn't evidence of consciousness of guilt because she was selling it in 2023. Rather, it was stuff that didn't get sold in 2014. However, the judge said clearly they being the defense, had not laid the foundation for this. And it was Josh Zellman who said, well, Georgia Keppelman did. But the defense did not call a witness. And I think that was because Donna didn't end up testifying. Had she testified, she would be the only one who could have spoken to that on behalf of the defense, right? I mean, I guess technically they could have called Harvey and he could have said, but I don't know if that would be hearsay. Because, yeah, it would be, right? Because if defense calls, he can't say what Donna said because it's the same party. The hearsay exception would be opposing party. So, because Donna didn't take the stand, they couldn't get that in there, and Judge Everett was like, no. So, I mean, that's just basic rules of evidence. During trial, defense sought to admit complete planners to correct the misrepresentation expected to be made by the state, and which came to fruition during the state's closing argument. Yeah, she was trying to sell stuff. It looks sus. You're leaving the country, you're selling your things. That's not what we normally do before vacation, ma'am. The majority of us have taken vacations.
That's not how it goes.
And then you're leaving stuff like Wendy to sell the gun. For what reason? I can't wait till you get back, because remember you're coming back for the bar mitzvah. Okay. The state argued that, I think it's supposed to be Mr. Markel's tag number in the 2014 planner was evidence Mrs. Adelson provided the tag numbers to the shooters, despite there being no evidence this happened. Again, that's where I think Sigfredo would have an in if he would be willing to come and talk to the state. And like, again, he might not get any time off, but he could negotiate like, hey, Katie's testified in 2 trials. I'm going to tell you this is the tag number was here, yada, yada, yada. Because the only one who's really spoken about what was in the envelope that Charlie put in Katie's diaper bag is Luis, and he can't read. So anyway, Rivera testified there were words on the photograph given to Garcia, but no evidence was offered as to what those words were, because he can't tell you what they were. 23 planner, state argued the planner indicated in anticipation of fleeing the country that Mrs. Adelson was selling personal items. So we talked about that. Admission of the complete planner would have corrected the misrepresentation by the state, as there were 39 other entries in the planner where Mrs. Adelson listed to sell the identical items as far back as January 2023. But see, that would also be left up to the jury. Oh, this door is open. Hold on. Anyway, focus. Okay, breath. You could have, like me, for example, I have a buffet, which I use as a bar because at the bottom it has slots for wine glasses. I don't drink anymore, but the wine glasses are there. And the top is like, you know, when you're having guests over, you set the pies out or the dishes out and there's a mirror. Well, I've been selling that thing since probably 22 when I got pregnant because I'm like, it's not going to be baby friendly. It's still in there. I would probably list it again, right? I'd never really tried to sell it in earnest. Like I put up some listings, but I didn't want to do like, what is that? Facebook Marketplace. I didn't want weird people coming in and out of my house. But definitely if I'm moving from here or leaving, I'm going to try to sell it again. Why am I going to move it to the new place, right? So in and of itself, trying to sell it before and not being successful and selling it again doesn't mean that she wasn't fleeing the country. But it's interpretational. It's something you put before the jury and let them decide. However, you have to follow the rules of evidence to get this in front of the jury for them to make that decision. Without doing that, I mean, that's not something for the appeal court to decide. Like that Judge Everett misinterpreted the rules of evidence. It's a stretch, you know? I think it's Donna who was like, make sure that's in there. Just like she was reading through, I mean, because this is 18 pages, right? Just like Donna was reading through the motions for Wendy and writing in stuff. I just feel like that's what has happened here. You let me know if you think this was all Fulford and Zellman, but I'm just like, it's a stretch. And all by itself, like if that's the one thing that you have on here, do you think that gets you a new trial? Or are they trying like, let's throw everything at the wall and see what sticks? Because I feel like it's so minute in the grand scheme of things, right? Of like, there's other evidence that she was not planning on coming back. Like her text message of like, I'm next, but I won't let that happen. The phone call where she's going over non-extradition countries. Like, are we really tying it to, oh, if we would have got that planner in there, the jury would have had a different finding about her consciousness of guilt.
It's a stretch. They're back in yoga class.
Okay. Judges have a duty to admit that does not fit neatly within the confines of the evidence code to protect the defendant's right to a fair trial. Again, I think it's just one thing in the totality of all the evidence that it's not. But it sounds like they're agreeing it's outside the confines of the evidence code. But yeah, I think it's a stretch. As the court admitted portions of both planners, there's no question concerning the authenticity of the material. So they're saying there's no need to lay a foundation. We already authenticated it. Exclusion of the planners infringed on Mrs. Adelson's right to present a defense. You needed someone to talk about it, though. when we added the other stuff in, someone was speaking about, oh, there's the tag number. You can't, like, what were you going to do? Just go up here, jury? Here's the planner. We think this show, like, you're going to testify? Defense? I don't get it. Thus, the court erred in excluding the planners as evidence. It goes without saying, oh wait, what is our header? For other cause not due to Mrs. Adelson's fault. She did not receive a fair and impartial trial. It goes without saying that all defendants are guaranteed a fair and impartial trial under the Florida and U.S. constitutions. Fair. Due process clause of the 14th Amendment guarantees the right of state criminal defendants to be tried by an impartial jury. Woods v. Duggar. Or Duger. 14th Amendment incorporates the essence of the 6th Amendment right to be tried by a panel of impartial, indifferent jurors whose verdict must be based upon the evidence developed at the trial. Irvin v. Dowd. Citations omitted, so we can't look it up. As Chief Justice Warren has observed, you and I'm sure the judge knows what it is. The constitutional guarantee of due process requires the court to safeguard against the intrusion of facts into the trial that tend to subvert its purpose, so are more probative than prejudicial. Specifically, the courts must vigilantly guard against the atmosphere in and around the courtroom becoming so hostile as to interfere with the trial process, even though all the forms of trial conformed to the requirements of law. Okay. So, court explained in Schutz v. State, the presence of courtroom observers wearing uniforms, insignia, buttons, or other indicia of support for the accused, the prosecution, or the victim of the crime does not automatically constitute denial of the accused rights to a fair trial. Were people in there wearing Fry Donna shirts? What are we talking about? What's going on? There are situations where the atmosphere in the courtroom might infringe on the defendant's right to a fair trial.
Do tell.
When such a claim is raised, a case-by-case approach is required to allow courts to consider the totality of the circumstances. A defendant claiming she was denied a fair trial must show either actual or inherent prejudice. Okay, let's get to what they're saying happened. Court would rule against the defendant on many occasions.
Defendant should put up better arguments.
The members of the gallery supporting the state would laugh out loud. Lol, lol, lol. Counsel for the defendant brought this to the attention of the court, and the court appropriately advised the gallery that this was not acceptable. Okay. The court did this on more than one occasion. However, the conduct continued throughout the trial, and the court took no action to remove those who violated his order. Did defense raise this in real time? Like, Your Honor, that's the 6th time they've been back there with the giggles. Let's get them out of here. Or is this something you thought of on that midnight train to Georgia? This undermined the credibility of the defense in the eyes of the juror. Says who?
Which juror told you that? I'm waiting. Oh, you can't hear me, Jackie? Joshy? Okay.
Not only were they laughing out loud, videos and images captured through the live video casting revealed gallery members making faces and moving about to capture the attention of the jurors while testimony was underway. Yodelay-hee-hee. Somebody please show me that footage. Who was doing that? And who made any more faces than Donna Adelson? Ma'am is missing her Botox. She was like, oh, I forgot my face could do all these things. This interfered with the jurors' ability to focus on the evidence and distracted them from closing arguments.
Which juror told you that? Did you poll the jury? Because now you're just pulling stuff out of your nether regions.
The court admonished the defendant on numerous occasions,
Fix your face!
that she was not permitted to show any emotion in the presence of the jury. Who was that? Nene Leakes from the Housewives of Atlanta. Fix your face. Her and Sheree, I think. It might have been Sheree who started it. Maybe I can find it. Fix your face. Donna needed to fix her face. The law does not require that a defendant appear without any emotion. I don't think I heard the judge say you need to be without emotion. I think he was like, control yourself. Like, there is a sort of decorum, right? Most of us work with other people. We don't just get to like just have like our face breakdancing during conversations, which Donna seemed to just, I mean, she's done that back when, since Lascalza represented her in her first hearing in front of Judge Everett. I think a lot of us use that one face as a part of our thumbnails, right? Where she was acting a fool and he had to tell her, control yourself. Like, you're an adult. Comport yourself accordingly. My 2-year-old doesn't make that many faces. In fact, as in this case, appearing to be cold to the seriousness and evidence in the case may cause the jury to believe the defendant had no care or concern for what the victim endured. Now they're saying, as in this case, based on what? Self-serving hearsay. That's my new favorite word. Thank you. Who was that? That was Brian Boone's attorney, Josh Martell. A lot of legal Joshes in Florida. Yeah, self-serving hearsay. Nobody said, like, they looked at Donna and thought she was cold and calculating. She was crying with no tears. And again, she's had opportunities to show remorse where she didn't, like when she was trying to get to Vietnam. Instead of copping to it, which people would have understood, she instead was like, my husband said, we should go, we've been there before. And, you know, I just needed to just get away. I mean, the jury didn't see that part. We saw that part. But you know what I mean? She's had moments to show contrition. When Ruth Markel was up there, again, jury didn't see this, but she's like shaking her head as if to say, like, no, you're wrong. She's shaking her head at other part. I don't know. There are other ways to convey contrition without doing facial gymnastics. Okay, during the course of the trial, prior to the reading of the verdict, the defendant did not do anything to disrupt the proceedings. Nay. She was making faces, faux crying during the autopsy photos. I would disagree. I think there are times on the record when he called her out. And, I mean, I don't know, because the appellate, this is not an appellate issue. Like, the judge was there, but I was going to say, like, the appellate court probably can't see the video, but will read only transcripts. But Judge Everett was there. He remembers. She did become tearful, if that is code for tearless, during her first sight of autopsy photographs and got choked up when her children appeared to testify against her. So if that's her first sight of the autopsy photos, that's the defense's fault, because y'all should have prepped her. You knew they were coming up. She knew they were coming up because Charlie talked about it on the phone with her. Like, oh, they kept flashing those. So if she hadn't seen them, she should have been prompted, like, oh, Charlie mentioned those. I don't want to be caught off guard. Can we look at those prior to getting in the courtroom and me being on camera? You know, something. She did not speak out. She was not sobbing out loud. She was not crying out. Well, thank God. She did need tissues to wipe away her tears, but she made no noises that distracted the jury in any way. You can be distracted by things other than noise, like all the body movement, the head shaking, by defense. Even the victim's parents noted that she showed no remorse due to her lack of emotion during the trial. That's not what they said. They said she showed no remorse in the totality of from 2014 to now, is how I interpreted it. I didn't hear them say she wasn't making enough faces and sounds, so therefore she was. I mean, they can't even see her. They're sitting behind her. They can't see her face.
Stretch much?
This impacted the decision of the jury, resulting in Mrs. Adelson not receiving a fair trial. What impacted the decision of the jury? That she was not allowed to sob out loud? That she was not allowed to cry out? What? Okay. The state presented evidence and testimony over a period of 6 days. The defense had requested 4 to 5 days for its case. On the second day of the defense's case, the court demanded, here we go, she didn't have enough time. She's had 11 years. The court demanded that Mrs. Adelson decide whether she would testify. Both counsel for Mrs. Adelson as well as Mrs. Adelson herself repeatedly advised the court that more time was needed to discuss the evidence admitted and the pros and cons of testifying based on the volume and substance of the evidence admitted during trial in order to make a knowing and intelligent decision in what was probably the most important decision in her life. No, the most important decision was deciding to kill Dan Markel. Like, let's not be funny. She had 11 years. You also had every day of testimony. You could have met with her afterward. Or the woman who was petting her back, rubbing her, could have met with her afterward to look at that. You could have had a daily checklist of the testimony. You didn't have to wait until they fully rested, number one. Number two, she made that decision at the end of the day, slept on it. She could have come in now, I think, to be fair, the defense said they rested in front of the jury, because I remember in like Lori Vallow Daybell's, she wasn't going to testify, but she didn't rest until the next morning. So that could have been a little awkward, like, to be fair to everyone, right? If they unrested so she could testify the next morning. But she could have. And I believe Judge Everett would have allowed it. But and then he gave them time Monday. They left early. Something happened on Tuesday. Because I believe, if I remember correctly, this decision was made on Wednesday. At any rate, this was especially significant in that the state made numerous changes to evidence during the trial. So I'm going to call BS on this, because I think maybe we didn't go over the full list, but there were multiple channels that did. I talked about some of it, but there was a full list of everything that was admitted that was potential evidence. And then, of course, you have to go through the process of what was admitted on the record. But again, prep work, right? If they admit this is what we're going to have to cover. This, you could have had some pre-trial discussion about it and then gone through the list every night of like, this is what they showed. This is what they showed. Here's how it's implicated. I mean, let's be real. Donna wasn't ready for Georgia. Like, Georgia Cappleman was bringing that heat, and especially after she ripped up that attorney Bailey, Donna wasn't ready. They wouldn't have had as long of a time deliberating as they did had Donna taken the stand. We saw her, the jury didn't, during her bond hearing. She was awful, not credible, going on and on about her pain and carbs and who cares, and how her husband told her, we just need to get away.
What is wrong with Palm Springs?
When the court or somewhere rich people go, I don't know. They don't go to Martha's Vineyard, really. That's for the brown folk. Well, where do they go? She could have come to the Hamptons. I like the Hamptons. You could have got away there. Why did you have to get an expedited visa? Like, you're already stressed the F out, and then you're going to add more stress? Trust me, I had a lot of stress trying to get a passport so I could fly domestically in my own country. Because I couldn't get the U.S. whatever. What is that new license that you have to fly domestically? It was easier for me to get the passport. It would cost more, but it was easier. It was stressful. So getting a visa, not a 30-day visa, like within a week, that sounds stressful for somebody who needs to relax. Just saying. Counsel drove to the detention center to meet with Mrs. Adelson for 2 hours authorized, arriving at approximately 5 p.m. Counsel did not have enough time to go through every exhibit with Mrs. Adelson during this meeting. That's why you don't wait to the last one. You go every night and go through what was covered for that day. Counsel advised, like, if you're prepping for an exam or some type of standardized testing, you don't wait till the night before the exam to start doing it, right? There's usually different parts, language, math. You do it in sections, and then you do it cumulatively at the end. Okay. Counsel advised the court of this fact, I mean, let's play devil's advocate. What else did they want? Did they want the judge to give them a week to decide, to go over everything that was covered in the 6 days of the testimony? Did they want 6 days with Donna to go over what the evidence was? Like, what was the alternative? What, they're not clear on what option the judge should have taken, nor did they mention it contemporaneously, right? They just said more time. And even when Josh Selman stood up and was like, oh, I need more time, and he was like, what would that accomplish? Judge Everett was like, what would that accomplish? He was like, well, that's what I need to talk to her to figure out. No, sir, then you don't have a plan. You don't need to talk to her. There is a big wasp. I'm glad I closed that door in time. Not only did the court force the defendant to make an uninformed decision, oh my God, inflammatory, hyperbolic, emotional. That was just emotional. There was no forcing. It shouldn't have been uninformed. If it was uninformed, it's due to counsel, poor counsel. This would be good grounds for ineffective assistance. Although they did the best with what they had. Okay, hold on. The baby doesn't like me shouting. He is tensed up into a big ball. Sorry, little one. Not only did the court force the defendant to make an uninformed decision, he threatened to hold counsel for the defendant in contempt of court because they were continuing to speak to their client about this important decision that she had to make. Because you know, when the judge tells you to zip it, you're supposed to zip it. So, yeah, he threatened contempt of court because you were in contempt. He runs a tight ship. Nobody is unclear about that, which again brought an audible derogatory response from the gallery, and the jury wasn't there. So what is your point? Anytime anybody gets admonished from the judge, I don't have them on right now, but I grasp my pearls, and I feel like when you do grasp your pearls, audible derogatory responses are appropriate to accompany them. A lot of people clutch their pearls like, oh my God, they're still talking. They didn't hear the Honorable Judge ever tell them to zip it. Okay. Oddly enough, whenever the state needed additional time to set up electronics for opening statement, for witness testimony, for closing argument, and even additional time to make their closing argument, the court not only gave them the additional time, he joked with the prosecutors about it. He did joke at the end. Well, Georgia joked with him first about the loose 7 minutes or whatever, and then he joked back. But y'all could have made a joke. You were stalling, again, with no clear alternative. What were the other things? Like, when Judge Everett had said, and what do you expect to accomplish, or what will that accomplish? If you would have said anything but, that's what I'm going to find out. Say, I've got 4 points I want to review with her just so she's clear. Something. I need 10 minutes. But I didn't get the feeling that Donna wanted to make a decision at all that day. But nobody was saying that. Like, we want to take tomorrow off to talk to her. Say that. So the judge can tell you yes or no. But you didn't say it. So he was just like, let's get on with the show. It's like if a kid is having a tantrum and you're like, I have a 2-year-old. Well, what is it that you want? And they don't know. Then at some point, you're just going to pick them up off the floor and go on about your business. Because they probably need a nap. Maybe Donna needed a nap. The court showed favoritism to the state at most every juncture of the trial. This is pure Donna. Are we really talking about favoritism? It's not like your children, Donna, where you have to pick one. Your children specifically. Good parents don't do that. While the trial had delayed starting times to accommodate the state's needs, the defense was required to meet its task over the lunch break. Oh, no, you didn't. Now, didn't Jackie say she took some sleeping pills or something and that's why she wasn't there on time twice? She didn't ask for permission. She asked for forgiveness. But now the state is the favorite. Okay. thus not allowing counsel time to adequately meet the obligations of counsel for the trial, resulting in the inability to consume lunch over the break. Are we back to carbs? Tell me that's not Donna Adelson. Donna Sue? Did you not get to eat? Bring snacks. Oh my God. Is that why Jackie's suits weren't fitting? Because she didn't get lunch every day? She just started to shrink and the suits got bigger? The court sustained the objections of the state without giving the defense an opportunity to respond. Maybe it's that little thing called no speaking objections. Under some situations, sidebar arguments were made. Oh, so you did get to speak. You did get to respond at sidebar outside of earshot of the jury. But on more than one occasion, so twice, the court denied the defense's request to approach because he had already made his decision and he didn't want to hear from y'all. That is not specific to defense. Additionally, even when the court sustained a defense objection at sidebar, okay, so they did sometimes rule in your favor. This sounds like Lori Vallow. Daybell, well, if you had made some arguments that made sense, I don't know if that's exactly what Judge Boreski said. That's the spirit of what he said. When the sidebar was concluded, the court announced to the jury that the objection was overruled. No, the court announced for the record that it was overruled or it was sustained. Do you want them to guess? I mean, sometimes we do, because you guys know I watch with Emily D. Baker and she'll be like, oh, sounds like he sustained that or blah, 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 based on how they continue. But okay. It was in fact overruled. Is an announcement inappropriate? Is clarifying what happened inappropriate? Also, I feel like it lets the person on the stand know, like, you can continue speaking or not. If it's sustained, zip it. Although, that might be just us court watchers who know, because I feel like sometimes things did get sustained and then the person kept talking and they had to be corrected. But do you know what I mean? Like, okay, it was overruled. It was sustained. Is that a secret? During one sidebar discussion, the court asked counsel a question. As counsel attempted to answer the question, counsel was met with a scolding to not talk over the court. Okay. That comes with everybody. Don't talk over the court. If there's a question, wait for him to stop talking. The court reporter can't record two voices at once. We all know this. Counsel thereafter was prevented from answering the court's question. I need specificity. Was it a rhetorical question? Stop playing with me, defense team. Was it a rhetorical question? Did he really need an answer? The temperament, oh now we're going into temperament, we're getting real personal, of the court towards the defense counsel was regarded as negative by whom, and gave the appearance of partiality for the state on the part of the court to not only the defense, but spectators in the gallery, the media, and those viewing the trial through the media. Well, I'm one of the ones who viewed it through the media, and it did not give me the appearance of partiality for the state, not once. Fellow defense attorneys commented that they had appeared before the court in trial on similar charges, and they were shocked to see the obvious disdain the court showed toward Mrs. Adelson and her counsel in this case. Tell me Donna did not write that. Doesn't that sound like when she told Sammy, the hitman or the bump man, I talked to 10 or 12 friends of mine about this. So you talked to some attorneys and they said, can you put it on the record? What is their bar number? Although there is a standard jury instruction to the jury that they are to disregard anything the court may have done that led them to believe he favored one outcome, yes, and he said it, I remember, over another, that was read in this case, it is not realistic that a jury can set those feelings aside. Okay. The jury clearly disregarded the instructions of the court on other issues and did so on this instruction as well. Clear to who? Stevie Wonder? because we are still not clear on that jury instruction about not posting specifics of that trial. Because as I recall it, or as I understand it, the foreperson never said which trial she had become a jury member of. Okay. The totality of circumstances present during Mrs. Adelson's trial establish inherent prejudice, to wit, there was an unacceptable risk of impermissible factors coming into play. Wherefore, the defendant respectfully requests that this honorable court grant this motion, grant Mrs. Adelson a new trial, and for such further relief as is just and proper. Certified by the Zellman Law. Honey. I hope after that Donna was feeling refreshed, that Zellman was feeling refreshed, because that was a lot of stretching. That was a lot of reaching. They tried it. What would be different? They would get a whole new jury. At least they stopped complaining about, like, the venue, because they didn't raise that again after they seated the jury, and they did say on the record. So now they're trying another workaround about a faulty jury. But I don't see how, even if the woman had said, I have been seated on the Donna Adelson jury, which my understanding is she did not, how would that have impacted her ability to listen and be impartial to the evidence? Do you know what I mean? Like, again, unless in the comments it was like, oh, hang her up by her feet, or I don't see it. But, you know, every defense attorney does this after every loss, and so I'm not surprised that they filed something. I just find the wording to be emotional, like too emotional for attorneys, in my opinion. But, you know, you let me know what you think, and they're getting their money's worth. What is it? Jackie Zellman's riding around in a new Hummer that's with the license plates. Trial me. I don't know what Josh is doing. Maybe Donna and Harvey's burial plan are thrown in there, although they probably want to be in Miami. Maybe they'll be cremated. That was the other thing too. I want to do Jackie's closing, and I'll cover it in there. She sounds like a funeral home director in some of this, where she's like very empathetic to Dan and the Markells, and like as if she's doing his service, which I just find odd. But maybe or maybe she feels like that would make Donna more likable. I don't know. Let me know your thoughts on that too. But yeah, that's it, guys. That's enough. That is enough. I will talk to you in the comments, where I won't be winded because I'll get to type. I should show you the bump. Let me see if it will show up on this white. Yeah, there we go. There. This baby is like way up in my lungs. 6 weeks to go. I appreciate you. Thank you for hanging out with me. If you made it this far, I especially appreciate you. And I look forward to talking to you in the comments. Toodles!